Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Here is a brief of what all happened in the Indian courts. Starting with the updates from the Constitution Bench of the Supreme Court, which today continued hearing petitions on same-sex marriage or marriage equality. Today, the Supreme Court bench observed that the Indian Constitution itself was a tradition breaker. The Constitution bench, comprising CJI D.Y. Chandrachud, Justices Sanjay Kishan Kaul, S. Ravindra Bhatt, Hema Kohli and P.S. Narasimha, was hearing senior advocate Rakesh Dwivedi for the respondents, who said that the issue was best left to the Parliament. As earlier also in reforms such as dowry prohibition, the courts had held it for the legislature to decide. He said the first question to be considered was whether there is a fundamental right under the Constitution for persons in same-sex relations to marry. He further submitted that heterosexual couples had the right to marry as per their personal law, custom and religion. Here, Justice Ravindra Bhatt pointed out that even intercaste marriages were not permitted traditionally. However, with time, the context of marriage had changed. The judge orally remarked, and I quote, "Nothing is granted. We are free citizens. We have taken this to ourselves. Right to speak, to associate. These are part of our inherent rights. Constitution does not grant. Even legislations have only recognized. So even the right to marry is inherent. If we say that this is inherent, it is a part of the Constitution." Further at the hearing, senior advocate Kapil Sibal, appearing for Jamaat Ulema-e-Hind, argued on the statement given by petitioners earlier that the Parliament was not going to recognize this issue and so the court had to give a declaration. He said that any law of this nature would require discussion inside the Parliament, in families and in society. Therefore, a declaration by itself on the assumption that Parliament was not likely to pass laws would be a wrong step forward. As such, a declaration by the court would close the debate in Parliament. To this, the CJI said that the court had in past also issued declarations. For example, right to clean environment, right to education, etc. So it was wrong to say that the court could issue a declaration. The Constitution bench will continue the hearing tomorrow. You can also watch live proceedings from the Supreme Court on our YouTube channel. In another development, the Supreme Court today agreed to list on May 15th a plea challenging the Kerala High Court's order, which refused to stay the release of the controversial film The Kerala Story, which hit the theatres on last Friday. The plea was mentioned by senior advocate Kapil Sibal before a bench comprising CJI D.Y. Chandrachud and Justice P.S. Narasimha. On May 5th, a division bench of the Kerala High Court comprising Justice N. Nagaresh and Justice Sophie Thomas had refused to stay the release of the film. The court had observed that the film only said it was inspired by true events and that the Central Board of Film Certification had certified the film for public viewing. The bench also watched the trailer of the film and opined that there was nothing offensive to any particular community in it. The second update on the issue is that the makers of the controversial film have approached the Supreme Court challenging the decision of the West Bengal government to ban the movie. They also allege that the movie is facing a shadow ban in Tamil Nadu and seek protection for screening the film in the southern state. For further updates on the matter, stay tuned with us. And now coming to an update on the BJP-led Karnataka government's decision to scrap off the 4% reservation provided to Muslims in the other backward classes category. You already know about the petition filed in the Supreme Court challenging this decision of the Karnataka government. Today, a bench comprising Justices K.M. Joseph, B.V. Nagaratna and Justice Asanuddin Amanullah were informed by senior advocate Dushyant Dave about the comments being made by public functionaries on this reservation matter when the issue is pending adjudication before the Supreme Court. Dave, appearing for petitioners, invited the bench's attention to the comments made by the Union Home Minister Amit Shah, where the Home Minister said that he has withdrawn the reservation to the Muslims. This is despite the fact that in the last hearing, the Solicitor General of India, on behalf of the state of Karnataka, made an undertaking before the court that the decision would not be implemented. and the earlier regime related to Muslim reservation as per the 2002 notification would continue to hold. The Supreme Court expressed its disapproval of such public comments today. The bench did not hear the matter on merits today as the Solicitor General sought adjournment in view of the Constitution Bench hearing in the same-sex marriage, and thus the matter was posted for July 25th. And now an update on the Bilkis Bano case. The Supreme Court today adjourned to July 11th the hearing in a set of pleas against the premature release of the life convicts in the Bilkis Bano case. The petitioners submitted that one of the respondents could not be found to complete the service of notice. So the bench directed steps to be taken to serve him with a fresh notice and to publish a public notice in 2 daily Gujarati newspapers. A bench of Justices K.M. Joseph, B.V. Nagratna and Asanuddin Amanullah was hearing a batch of petitions challenging the decision of the Gujarat government to grant remission to 11 convicts who had been sentenced to life imprisonment for multiple murders and the gang rape during the 2002 communal riots in Gujarat. The Supreme Court today reserved its order on a plea moved by former IPS officer Sanjeev Bhatt, seeking the recusal of Justice M.R. Shah from hearing his case. The background is that in July 2019, the Sessions Court at Jamnagar in Gujarat had sentenced Bhatt to life imprisonment after finding him guilty for the custodial death of one Prabhudas Madhavji in 1990. Senior advocate Devdutt Kamath, appearing for Bhatt, requested Justice Shah to recuse from hearing, considering the fact that he has passed strictures against Bhatt while hearing his petitions arising out of the same FIR as a judge of the Gujarat High Court. Kamath stated that Justice Shah, as a judge of the Gujarat High Court, had observed that Bhatt was attempting to delay the trial while dealing with his discharge petition. In the present matter as well, where Bhatt is seeking to produce additional evidence, the allegation is that he is attempting to delay the hearing. Senior advocate Maninder Singh, appearing for the state of Gujarat, opposed the plea for recusal. He said that several other cases of Bhatt had been dealt by Justice Shah, and in none of those cases a plea for recusal was made. He said one could not seek recusal selectively. The Supreme Court bench of Justice M.R. Shah and Justice Ravi Kumar today reserved the order on the same. Also, let me tell you here that Justice M.R. Shah is set to retire on May 15th this year. CJI D.Y. Chandrachud today orally remarked that the Supreme Court on an administrative side had been working towards making transcripts of court proceedings available in regional languages. The remark was made during the hearings on marriage equality petitions before the Constitution Bench when senior advocate Rakesh Dwivedi pointed out that although live streaming was a step in the right direction, the issue was that all debates happened in English in the Supreme Court and people living in the villages or small towns could not understand and follow the same. Let me tell you here that in 2022, the Supreme Court live streamed its proceedings for the first time. This started during the term of former Chief Justice of India, U.U. Lalit. In February this year, the Supreme Court commenced the utilization of artificial intelligence and technology powered by natural language processing to provide live transcripts of its hearings. The transcripts are uploaded on the court's website. In an important development, the Patna High Court today rejected Bihar government's application to prepone hearing in the writ petitions challenging the caste-based survey in the state. You already know that last week, while hearing petitions challenging the Bihar government's decision to conduct a caste-based census in the state, the Patna court in an interim order had stayed the caste-based survey. The court prima facie had said that caste-based survey amounts to a census which the state government has no power to carry out. The matter was posted for hearing on July 3rd. Now, seeking an early hearing in the matter, the Bihar government last week moved an interim application before the High Court, saying that though the High Court's order dated May 4th was interim in nature, it has finally adjudicated the issues under consideration. And so the matter could be disposed of. But the application was rejected by the Patna court today. To read more about the case, you can click on the link given in the description box below. In another update, a public interest litigation has been moved in the Delhi High Court against Congress leader Rahul Gandhi and Delhi Chief Minister Arvind Kejriwal for allegedly making false and misleading statements accusing the union government of waiving off loans of various industrialists during the year 2020-21. The plea has been moved by Surjit Singh Yadav, claiming to be a farmer and social worker by profession. The petitioner has sought directions on news channels, News 24 and NDTV, to remove the allegedly false and misleading statements made by the two political leaders from their electronic media platforms. He had also sent a legal notice to the politicians and news channels in August last year seeking apology and removal of the content. However, no reply was received. The matter is likely to be listed tomorrow. Stay tuned for further updates. The Madras High Court has directed the Bar Council of Tamil Nadu and Puducherry to respond to a plea by a fifth-year law student challenging the enrollment fee charged by it from law graduates belonging to the scheduled caste and scheduled tribe communities. The petition states that in the government law colleges, the tuition fee itself is not beyond Rs 500. When the Bar Council is charging such an exorbitant amount without any concession, it affects children coming from less privileged backgrounds. The court prima facie agreed that the amount was high and issued notice on the petition. Bar Council of India and state government have also been issued notice by the court. And now coming to the news from Uttar Pradesh. Disqualified MP Afzal Ansari has moved the Allahabad High Court challenging his conviction in the Gangster Act case where he has been sentenced to 4 years in prison by the Ghazipur MP MLA court. In a separate plea, he has also prayed for a stay on conviction during the pendency of the appeal. You already know that the case under the Gangster Act against Afzal Ansari and his brother, former UP MLA Mukhtar Ansari, was registered for their involvement in the kidnapping of Vishwa Hindu Parishad office bearer Nand Kishore in 1996 and also in the murder of BJP MLA Krishnanand Rai in 2005. Significantly, 2 days after his conviction, Afzal Ansari was disqualified as a member of Lok Sabha from the date of his conviction. However, this disqualification can be reversed in case the High Court grants a stay on his conviction or it goes on to decide the appeal moved against the conviction in favor of Ansari. Also last week, the Allahabad High Court has directed the Director General of Police, Uttar Pradesh, to accord full security to Mukhtar Ansari while shifting him from one jail to another and while producing him before any court, from jail and on the way or any other place. To know more about the matter, stay updated with livelaw. And lastly, coming to the principal bench of National Green Tribunal, which today constituted a joint committee comprising Delhi Chief Secretary, Principal Secretary Environment and Forest, a nominee of Delhi Urban Art Commission and District Magistrate North to ascertain the factual position about alleged violation of environmental norms at the residence of Delhi Chief Minister Arvind Kejriwal. The tribunal bench of Justice Adarsh Kumar Goyal, Justice Sudhir Agarwal and Dr. A. Senthil was hearing an application alleging that there had been violation of environmental norms in the constructions at the residence of Delhi Chief Minister Arvind Kejriwal, and that in the course of development, permanent and semi-permanent constructions were raised and more than 20 trees were cut. While constituting the committee, the NGT also directed that a meeting may be held within 1 week by it and the report may be furnished within 3 weeks from today. The tribunal has posted the matter for May 31st. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box below. Stay ahead with quick legal updates only on livelaw. Do not forget to like, share and subscribe and support us.